I'm Lottie, founder of the Jura Society. We are a community and concierge that explores what wealth means to modern women by providing them with the financial and legal knowledge to take control of their wealth and well-being with confidence. I am so excited to welcome Verity Sherwin and Clarissa Ferguson of Payne, Hicks to explore the practicalities of writing a will, from the life events that make it necessary or overdue to tax considerations, lasting powers of attorney, and trust structures. Please note this is for education purposes only. But now, over to the ladies. Thank you so much for joining us this afternoon. Please, could we just start with learning a little bit about who you are and what you do?
Thank you so much for having us. I'm Clarissa. I'm a legal director in the private client department at Payne Hicks. I've been here for many years. I advise on all manners of trust, tax, and estate planning matters, including wills. I advise individuals, trustees, onshore and offshore, and have a particular interest in landed estate matters.
Thank you so much for having us, Lottie. I'm Verity Sherwin. I'm a senior associate in the private client team here at Payne Hicks. Similar to Clarissa, I advise individuals, families, trustees and charities and more on their estate planning, succession, trust and tax affairs. Thank you so much for having us.
Brilliant. Well, I'm super excited to have you both here and to actually learn a little bit more about something that I know a lot of people put off. It's one of those things that we never think we'll need to have, or, it's one of those things that's always left on the to-do list. So let's just start with the basics. What exactly does a will do? And what happens if you die without one?
Okay, so very basically, a will is a legal document under which you can direct how your money, your property, your possessions, what we would call your estate, how it's distributed when you die. It allows you to appoint executors who can manage your affairs, name guardians for any children you have who are under 18, and generally outline your wishes in relation to your estate. When you're thinking about your will, it is important to note, however, that any jointly held property that you have, such as land or bank accounts, pass to the surviving holder of that asset and not under the terms of your will. A good example of this is any real property. So if you hold a house with your spouse jointly, and that's as joint tenants rather than tenants in common, then on the first death, the entire property will pass to the surviving spouse, irrespective of what you might think you have done under your will and if you wanted it to go to someone else. You've already said what happens if you die without a will. Then under English law, a set of rules called the intestacy rules will determine who inherits your money and your property.
Cool. Thank you so much. And yeah, again, that highlights the why, because you don't want somebody else taking control over your estate when you're not around to be able to actually say, oh, no, I didn't mean that. But talking about these intestacy rules, they produce results people don't expect sometimes. Could you walk us through a few of the most common surprises?
Yeah, absolutely. So the intestacy rules are trying to deal, as you say, with a scenario where there's no will to give instructions. And so the rules depend on which of your family members survive you when you die. So you'd look at the family setup and say, is there a surviving spouse? Are there children? Who are the family members? And then you just follow the rules for who gets what. And there's very little flexibility there. So two odd results. I'll just give you two examples. One would be if you were to die with a surviving spouse and two children with that spouse. So in principle, quite a standard nuclear family. People can often be surprised to discover that the surviving spouse would not take everything. So usually you might say, oh, I've got young children, I want my spouse to take everything because I trust them to look after the children. In fact, what would happen is that the spouse would get all of the personal chattels, so furniture, jewellery, such like, and a statutory legacy, which is currently the first £322,000, and then half of the residuary estate, so what's left after debts and etc. And the other half will be for the children on something called the statutory trusts, which aren't always satisfactory. The children take at 18, you can't, no older age. So it's not the scenario you'd necessarily have planned for, especially if your children are young. And a second example is if you had no spouse or children, you might be surprised to discover that actually the intestacy rules would then pass your assets to your parents in equal shares, which is usually, if you're looking at good tax planning, it's the opposite direction. That you would want to pass the assets in.
That's really helpful to know. And again, another reason why we need to be thinking about this in advance. But thinking about that, at what point in life should someone be thinking seriously about writing a will? And what are the trigger moments that should prompt an immediate review?
Well, we would say any time is a great time to think about your will, but you can legally make a will from 18. I think in practice, many of us only really, contemplate our estate and what should happen to our assets when we get married or when we have children. I know that was certainly true for me. However, there are other important trigger points. Probably the first is if you buy a home, often, your house is one of the most, if not the most valuable assets in your estate. And you're going to want to think about what should happen to that valuable asset when you die. Another trigger moment might be if you inherit significant assets from a friend or family. Are there any expectations about what should happen to those assets that you've inherited? Are they to remain within your family, or where should they go? Very importantly, if you start cohabiting with a partner but you don't get married, you want to think about what happens to your unmarried partner. Unmarried partners don't have an automatic right to inherit, and they're not covered under the intestacy rules. So if you don't have a will in place and you've been living with someone, it doesn't matter for how long, they don't have an automatic right under the intestacy rules and won't be able to inherit anything from you unless you've put that in your will. Another one is if you enter into a marriage or civil partnership. In England, a marriage or civil partnership actually automatically revokes any will you might have. So that makes it essential to redo your will if you haven't already got one, or to think about it for the first time, perhaps. Another one I think very important for those within the Juris Society is if you start your own business, you're going to want to think about what happens to that and succession planning, which I think we cover again later on. But those are the main trigger points. But really, any time is a good time to start thinking about your succession planning and considering what you're going to have under, put under your will.
Yeah, and I think that whole idea of sort of succession planning can be quite overwhelming for some people, and they might believe that their affairs are too simple to warrant professional advice. Where does that assumption tend to break down, though?
Well, again, it very much depends on kind of your personal circumstances, and it's worth, whatever your scenario, whatever your assets or family situation is like, reviewing your estate planning and thinking about whether taking some advice would be sensible. But and it's not the case. There's sort of a bit of a myth that perhaps professional advice is only for the super wealthy in this kind of context, but complications can come into your estate planning and succession planning in lots of different ways. 3 different examples might be, the first one is if you had some more complicated assets perhaps that would warrant targeted advice. So interests in a family business, or you founded a business and want to work out how that would devolve or be managed on your death, or interests in agricultural property. So it's not just as to value, but also as to the type of asset. A second example would be if your family's got some, don't like to say complications, but perhaps not as traditional. If you've had, let's say you've had multiple marriages and you have children from multiple partners, it's really important to take advice on actually how you want your estate to work, and what looks fair in that scenario for you, and where they might inherit assets elsewhere. So making sure you're looking at matters in the round if your family has sort of some complications to consider. And then a third example is the international aspect. So whether as an individual you're internationally mobile, or your assets, where they are, whether they're in different jurisdictions, is another sort of flashpoint for making sure you're taking professional advice, and making sure not only that you're taking advice in England and Wales, but that your advisor is linking you in with foreign advisors as necessary to make sure that you're looking at your succession planning in the round.
Yeah, I think that is so sensible, and it's often something that I think people might just overlook. But I think, what would a well-structured will actually contain, and what decisions does a person need to make before they can put one in place? So if anyone's watching this now and they're thinking, oh gosh, yes, that is on the to-do list, but I haven't actually got to that step because, you know, there are some missing pieces in my questions, what would you suggest?
I would say, first of all, in terms of what should be in a well-structured will, your advisor should be telling you that. So that's not something necessarily for you to worry about, and that's something that your advisor should go through with you, you know, straight away in the first meeting. But it should contain an appointment of executors. So these are the characters who will collect in all your assets, pay any tax due on your death, any debts, and then distribute your estate in accordance with what you've said in your will. Also, the hello, we're back. I'm
You are.
I'm so sorry. I think, did you we're on specific bequests or legacies. I think that's where it cut off.
Yeah.
So another thing to think about, what should be included in your will, if you would like it to be, is any specific bequests or legacies. So these are gifts of any specific items or cash amounts that you would like to go to particular individuals or charities. And something we often see is, if, you know, people want to give a cash amount to godchildren or nieces and nephews, that's very common. But sometimes people decide they don't want to give any specific things at all, and that's absolutely fine as well. Very importantly, you'll need to include directions in relation to the remainder of your estate. We often call this your residuary estate, because it's everything that's left after the payment of debts, taxes, and any specific legacies. And you want to say who you want the bulk of your estate to go to. And also, the will need to contain a contingency plan. So what happens if, you know, very unfortunately, the person who you intended to benefit is no longer alive when you die? You need to think who else you might like your estate to pass to. In terms of things to think about before putting your will in place or even going to see an advisor, well, a good place to start is thinking about what actually is in your estate. So valuing it, listing your assets, you know, property, bank accounts, investments, vehicles, personal possessions. Then also thinking about any debts, so mortgages, loans, tax liabilities you may have, just to understand the total net value of your estate and what you're actually able to give away. In terms of what you're able to give away, I mentioned at the very beginning, you know, joint assets that pass outside the terms of your will. So just reviewing those, so you have a really good understanding of what you can give away under your will and what will pass automatically. We see so many times people, you know, have thought that they own their property in a slightly different way, and, you know, you go and have a look at the land registry, and you see that it's held as joint tenants. So they might have to do something to sever the tenancy, or, you know, there's planning to be put in place and advice to be taken in relation to property specifically. Really important, and probably maybe the most important thing, identifying who you want to inherit. You know, that's that you can think about before you go and take advice, friends, families, charities, whoever. Selecting your guardians, obviously really important, and then also thinking about who you would like to be your executors as well.
Yes, and on that point of executors then, you know, it is a pretty serious role for anybody to undertake, and how does that choice work in practice? What should what should be thinking about when you are, you know, designating someone to be your executor?
Well, as you know, as Clarissa says, the role is a significant one, and it's worth sort of keeping in mind that it can be quite time consuming, and also depending, and quite emotionally heavy, and also depending on what kind of powers you've included in your will, could involve quite a lot of decision making, and you know, it's a significant responsibility and a duty on those individuals. So it's really worth thinking about who your trusted individuals are in your life, who you feel comfortable stepping in it's, in essence, your shoes in terms of distributing your estate and who your family are comfortable with, while also weighing that against the level of responsibility and time. So you might want to consider multiple executors, whether there's more than one person you really trust, and also weighing up whether or not to appoint a professional alongside a trusted individual. That will come with some cost, but may also come with peace of mind regarding expertise. So that's a way up in terms of the level of support that you might want to provide for that trusted individual or individuals. But your advisor can talk you through those pros and cons. If you have an idea of who your trusted people are, you can then talk through with your advisor, why it is that you think they might struggle with the role or find it stressful, and whether or not they'd be suitable, and how they could be supported in the role.
So just a off the cuff question on the back of that: if somebody is struggling as an executor, can they relinquish their position and get somebody else to come in? What happens in that scenario?
Well, you don't automatically, if you name a person in your will as your chosen executor, they still have the opportunity to decide whether or not to apply for the grant of probate. So you're not tying them down or forcing them into a role. They have the opportunity after your death to take advice and consider, do they want to take up that role and that grant of probate. So there is an opportunity to consider the matter. And it's also not as, it's not so black and white as it has a professional been appointed to support them, because they can take up the role but could still appoint solicitors to do the majority of the administration of the estate, notwithstanding. So, but yeah, it's helpful to know that they don't have to take up that role.
Yeah.
Okay, because you never know, things change and people change, and they might be overwhelmed at the time, so they might not be able to fulfill the duty. Going back to your point, Clarissa, some women in our community may hold assets in different countries, running a business, have children from previous relationships. What particular considerations come into play with this?
If we take, I think, each topic in turn, assets in other countries and other jurisdictions. If you do have assets in other countries, then you will need to take advice in the country where that asset is situated. So you would come to us and we would advise you from an English law perspective, and then we would need to take advice from the jurisdiction. So sorry we lost you again, Lottie.
That's fine. So you're just saying taking advice in the other jurisdiction.
Yes, yeah, very important. Many countries have forced heirship provisions or matrimonial property regimes, which would or could prevent you from leaving those assets to the people you want to, or in the proportions you want to. So it's very important to take the correct advice. In terms of running your own business, if you control your own business, you will need to consider, and your will need to deal with, any shares or partnership interests that you hold. Should they be passed on? Should they be sold when you die? And are there any restrictions in the article or partnership agreements that need to be looked at and considered? You'll want to think about who you want to run and manage your business if you want it to continue. If you have grown-up children, it may be that they are already involved in the business, or one child has taken a really active interest and the other children or other child does not. That's something that will need to be considered. Open conversations with the intended beneficiaries of your business around their expectations with the business, is very key. And then the business assets themselves and liabilities, are they assets of the business owns and holds, or do you own those assets and they're used within the business? Lots of different things to think about. And also children from previous marriages, you want to think again, we've spoken very briefly about guardianship, but that's a really important one to think about if you die whilst those children are still minors. What their inheritance will look like, and how you'll provide for your spouse if you remarry. often in situations where someone is married for a second time and they have children from their first marriage, they look to give their spouse an interest in the income only of their estate, with the intention to preserve the capital for their children, which they would inherit when the spouse dies. I think if you do intend for your spouse to inherit and also your children, you need to consider, if your children are going to have to then wait a long time for their inheritance. You want to think about, there's so many different things that impact your decision making here. Age of your spouse, age of your children, the relationship between your second spouse, your children for your first marriage. Do they get along? Don't they? But again, it's something you probably want to sit down and talk about with your advisor, and together you would come up with a good structure for your will to take into account all these different things.
Yeah, I think that's so important because, there are always these sort of horror stories, that come out in the wash after someone's passed and they've left it all to sort of the gardener or whatever that example was a guy who ran Hermes or something like that. I can't remember, where he'd left it to the gardener and everyone was like, hang on a second. However, how does tax planning fit into the will writing process, and what opportunities are most frequently missed?
So tax planning is a really important thing to keep in mind, that any good planning for your will should be looking to maximise the available reliefs and exemptions from tax, while still making sure to plan properly for your beneficiaries and to provide for them in the way that you want to, and adapt it to your personal circumstances. The starting point here, and the main tax you'll be thinking about in this context, is inheritance tax. Starting point is that it is chargeable at 40% on your estate when you die, above your available nil rate band and available reliefs and exemptions. So there's a starting point there that there's a substantial charge to tax. And there are exemptions available, key ones like spouse exemption and charity exemption, and key reliefs like business property relief. So you want to be making sure that when you're planning, you're making the best use of those exemptions and reliefs to make sure that as much as possible of your estate is actually passing to your beneficiaries. But the sort of corollary of that is that who you choose to pass your assets to affects how much tax is going to be charged. One point just to flag here is that although you want to have good tax planning in place and make your estate planning efficient, we often use the phrase that you shouldn't let the tax tail wag the dog. You want to make sure here that you're really sort of stepping back and thinking about why you're planning and for whom, rather than going down a rabbit hole perhaps of making your estate as perfectly efficient as possible, but then losing sight of who you want to benefit and why. So it's making sure you're looking at the tax planning in the round. But some opportunities that are frequently missed, some simple examples. Have you still?
Yep, examples.
Sorry about that. So some, an example that is making proper use of the spouse exemption. So it may be an option to we sometimes sort of say shamelessly using the spouse as a conduit to get assets to the children. So you might be able to give your spouse a life interest in your whole estate, and then pass assets to the children during that spouse's lifetime. So that's one option to consider. And there's also something that's often missed, is the 36% rate of tax rather than 40 if you pass 10% of elements of your estate to charity. So some testators may already be very generous and want to give a large amount of their estate to charity, and might come saying, I want to give a lump sum of a certain amount, and not realize that that's 9%. And if they just made a little bit more, that would then reduce the rate of tax and pass a lot more overall to their children or beneficiaries. So those are just two examples where just a little bit of advice can really make a big difference to your beneficiaries.
With that charitable giving element, does that need to be sort of gifted on death, or is it through their lifetime?
So that's on death in terms of how much goes to charity. So it's also then worth talking to your advisor about your lifetime planning. Is it more efficient to give during life or on death? It'll depend on the personal circumstances and other taxes involved, but it's definitely worth having a look at your charitable giving and seeing how that can be done efficiently.
Yeah, no, that's really good to know. We mentioned trusts. Could you explain the role of trust within a will and when they become worth considering as well?
Yes. Well, first of all, I think it's important to say there are so many different types of trusts that can be established on death under a will. But very generally, if assets in your estate are held on trust, then they won't pass outright to your beneficiary when you die, but they'll be held and managed by your executors or trustees. We use those terms interchangeably for their benefit. Trusts are definitely worth considering if you want to protect assets from beneficiaries who are young or vulnerable, or or even financially irresponsible. Parents know their children very well. They might say, this child, he may be 25, but he absolutely cannot inherit this amount until a later age. I just don't think that's appropriate, and we do see that very often. You may be surprised to know that if you set an age contingency in your will, for example, if a parent does provide that their child will inherit at age 25, then this automatically does create a trust interest. As I've said, there are lots of different types of trusts. Under the terms of a trust, a beneficiary may be entitled to the income before the capital if any age contingency is set. Under will, whilst you don't want the beneficiary to get the lump capital sum, that the trustees can give capital sums to them during their life for specific events, for education, for buying a house, etc. So they can be really useful and used well in those kind of contexts. They're also really worth considering if you want to give beneficiaries different entitlements. We've both touched on giving, a spouse an income interest and preserving capital for your children. We see that a lot, and it's very common in second marriages, and is a really good tool and a really good use of a trust, which we enjoy. It's worth noting as well that depending on the type of trust you establish under your will, different tax regimes will apply. There are special regimes for different and specific types of trust, and someone will want to need to take advice on that when their will is being drafted.
That's a really good point. And also, I think it's worth noting that if you do have life cover to cover any IHT, it's always useful to put that into a trust so it doesn't get stuck in probate when you've got to pay that off. So that's one of those little tiny financial planning tools that I think some people forget, or it's just not done at the right stage. So I'm sure you might see that often. But alongside this, what other documents should people have in place? And in particular, why does the lasting power of attorney matter so much?
So thank you for raising lasting powers of attorney. LPAs is what you'll often hear them called in practice. So try and bust some jargon there. An LPA, lasting power of attorney. It's a document we would absolutely recommend you looking at the same time as your will, and your advisors can help you with that. It's a really important document because what it allows you to do is choose attorneys who are your trusted individuals who would take decisions for you if you lose mental capacity. So an example here is if you were in an accident and went into a coma and couldn't make your own choices. These are the people who would step into your shoes during your lifetime to take those decisions for you. There are two types of lasting power of attorney: your property and financial affairs and your health and welfare. And you can choose different attorneys under those two documents. So if you feel that there are different individuals who would best make the choice for what kind of care you would receive and liaising with your doctors versus making payments of bills or choosing whether to sell your property, you can choose different individuals to be those attorneys. And it's even possible to have more than one property and financial affairs LPA, one to deal with your business assets and one to deal with your personal assets. So you can choose who those individuals that would step into your shoes would be in those different circumstances. But as the examples I just gave have shown, these are big decisions that will be able to have those documents in place. More and more institutions are expecting to see those documents before they let people take decisions for them. we would strongly look to have them in place to avoid the cost and delay of a worst case scenario as an application to the Court of Protection to appoint a deputy on your behalf, which is timely, costly, and far from ideal. So, simple as recommend looking at LPAs at the same time as your will, but remembering that they look after who would act during your lifetime, and that ends on death, rather than being a document that would survive your death. So definitely LPAs in place. You might also sell a letter of wishes. It often sits alongside a will and is private, unlike a will, which would become public when it goes to the probate office. So you might see a letter of wishes in place. And another document you might see or think about at the same time as your will is nomination forms. Clarissa's touched on assets that pass outside of your will. Another example would be pensions, making sure that you've put your nominations in place for assets like, where you want your pension to go, so that you're looking at all of your assets in the round at the same time as your will.
Yeah, and that's a really good point about pensions, especially as they're being brought into the IHT net now as well. There's a lot more planning and structuring needed in order to make sure that that money that you've accumulated during your lifetime is going to the right people at the right time, as you wish.
Yeah. And that's from April next year, so 2027.
Yeah, so get your skates on now if you think there is going to be some sort of planning required before then. Remarriage, divorce, the birth of a child. How do these events affect an existing will, and how quickly should someone act when these occasions arise?
I think I mentioned very briefly at the beginning of the webinar that marriage will revoke an existing will. So if you don't put a new will in place promptly, then the intestacy rules, which Verity spoke about, will apply to your estate. Now, wills can be made in contemplation of marriage so as to bypass the automatic revocation, but the will must name the spouse and it should be made shortly before event. What you can't do is, before you even have a partner, say this will is made, in contemplation of marriage, and with the marriage being however many years in the future, and you don't know who you're marrying.
Optimistic.
The second one, divorce. So upon a legally binding divorce, an ex-spouse will be treated for the purposes of your will as having died. Consequently, any gifts or executor roles designated to them in a pre-existing will become invalid. The rest of your will does remain in force, but this still can cause some significant issues such as partial intestacy if no alternative beneficiaries are listed. Often, if you do have a spouse as your main beneficiary, you would have a contingency plan, but not always. That can be missed. It's therefore best to revisit your will as soon as possible if you're, thinking about divorce or separation, because you're going to probably want to look at it before you get the divorce through. And as soon as you're separated, divorce proceedings can take a very long time. And if you wait the divorce for your spouse to be treated as having died, that might not be soon enough.
Yes, I've heard cases where that's happened, where during the divorce, the soon-to-be ex-spouse has actually died, and then it's gone to inherit by the woman or whoever that they didn't intend it to happen, and so that's a tricky one.
Yes, you're going to want to look at that, straight away, really. In terms of children, it certainly makes sense to review your will if and when you have children. It is possible to include children as beneficiaries before you have any. So, for example, you might say to your spouse, and then for any children that you have, you don't have to include them by name. That said, you wouldn't want to include children as your main beneficiary probably before you have any. That might seem a bit nuts. So again, children, if you have any, it's a great time to review your will and make sure you're happy with everything.
Love that. So let's just talk a bit about contentious wills. All the planning that we do as professionals is always thinking of the best possible outcome. However, we know that when humans are involved, things don't necessarily go to plan. So what are the most common mistakes that you see in wills that come before you in a contentious context?
Well, as part of this sends a little bit of a shiver down my spine, because we're obviously say trying to plan to avoid the pitfalls that might come about. But exactly as you say, Lottie, good planning involves trying to foresee those pitfalls and protect your estate from what might happen. And a lot of that is to do with getting to know the characters, understanding your family in terms of what, potential conflicts that could happen down the line. But in terms of sort of some pitfalls to look out for in the planning process that we see quite often, first example would be failing to provide for somebody under your will who might have a claim against your estate. So general principle. Under English, sorry, have still got us there. So I was just saying that a general principle is that under English law, you can provide for whomever you wish under your will. It's called freedom of disposition. But there is an act which allows for claims against your estate for certain individuals in certain categories. So that might include if you hadn't provided for a spouse or somebody that you'd been maintaining before you died. And failing to think about someone who might have a claim at the planning stage can lead to conflict down the line. So better to speak to your advisors at the time about potential claims so that you can see how you might provide for them or avoid that risk at the planning stage. And some other examples that can lead to contentious wills or conflicts, two other examples would be failing to take into account a prenuptial agreement or postnuptial agreement you might have entered into, which often will refer to and seek to agree how you would provide for that spouse on your death. So that can lead to a conflict if you fail to take that into account. And a third example would be failing to take into account foreign regimes that might apply to your assets. So Clarissa touched on this earlier, but if there's a forced heirship regime which might apply to certain foreign assets, failing to have considered that foreign implication at the planning stage can lead to some slightly messy probates. So better to sort of take that advice up front if you can and head off that risk.
Yeah, that's a really good point as well. Planning ahead, something that people don't think about when they are thinking about death. We want to live. But how should families be approaching conversations about inheritance, and at what point does it make sense to involve the next generation? I know that there's a lot of discussion about, getting the next gen involved in philanthropy so that they have sort of some understanding and some sort of, involvement in, say, family wealth and generational plans. But it can be a tricky and very emotionally fraught discussion depending on who the family members are, whether there is a division in entitlement or, it's not always equal. What is your experience and what are your tips?
I mean, absolutely, it can be very emotionally charged, but I think open conversations with children, especially as soon as they're mature enough, I think as with everything, the key is to manage expectations and involve your children if it's appropriate to do so as much as possible. And I think it's fair to say there is no one formula, no one size fits all approach. All families are very different and will require really different approaches. The key, I think, is just to sit down and start having that conversation as soon as possible. Everyone's very busy, but it's really important to manage those expectations and then, involve your advisor when you're ready to. The family dynamics, who gets on, who doesn't get on, what assets, how can those assets be split, the size of your estate, all these different things will come into play. But I think the key takeaway is open conversations as soon as possible, involving people, spouses, children, grandchildren, where appropriate, really.
Yeah, and that's it. It's about communicating. And I know some families just really struggle at that starting point. So, if that is the case, bringing in professionals as early on as well to help to mediate and to guide those discussions can provide some cohesion through some of those complex conversations. So this is where you guys come in to help diffuse any, fragmented families. But final question, we've made it through. If someone has been putting this off, So thinking about wills, thinking about legacy, thinking about, LPAs, all of these things that we've touched on, what is the most straightforward first step that they can take?
I would say give your advisor a call, or if you don't have one yet, feel free to give us a call. It's starting the conversation will make it less daunting. What might be helpful in advance of giving a professional a call is to have looked at your assets, to have an understanding of what you have, how much it's worth, and any debts you have, so that you can talk to the advisor. But the key point here is getting the ball rolling and breaking through that barrier of talking about what might feel quite daunting, which is a worst case scenario. Picking up the phone and speaking to someone who's used to dealing with this day in, day out, and has seen different families with different dynamics. We're not going to be surprised about a difficult child or a complication in a business. And starting that ball rolling and having that conversation should make the whole process feel more manageable and less daunting. And I hope what you've taken also from this talk is that it's so much better to have a plan in place than no plan. So you can't be making a mistake by picking up the phone and getting that ball rolling, really.
Yeah, I agree. I think that just dip your toe in and pick up the phone and see where you go from there. Thank you both so much, and thank you to everybody who's tuning in either live or you're watching us on the replay. So appreciate you, Clarissa and Verity, sharing your knowledge with us. And for anybody who has not yet, taken the leap into thinking about preparing their will, and that has been on your to-do list, I really hope this has given you the little nudge that you've needed to take action. So if you do want to reach out to either Clarissa or Verity, then feel free to do that directly or come through to me and I will direct you to them. So thank you both once again for this. Thank you. Have a good afternoon.
Thank you.
Thank you. Bye-bye.